Welcome to EB5 Investment Voice, where attorney insights intersects with immigration investments. If you are a foreign investor, domestic fund manager, or enterprising entrepreneur and want to get the most out of the EB5 program, you have come to the right place. I'm Mark Deal, and I'll be your co-host on this journey. I'm joined by your host, Mona Shaw, and other attorneys at Mona Shaw & Associates, as well as immigration leaders from around the world. So let's get into EB5 Investment Voice. Mona, on the last episode, when we were talking about the EB5 Reform and Integrity Act, we talked a lot about the visa set-asides, but I'm assuming that we didn't cover everything with regards to RIA. It's not all cleared up?
Well, great, Mark. You're actually using the acronym RIA because it is a real mouthful. Bill was great. But remember, Bill is experienced. He's been in the industry a long time. And this is the issue that we are finding. We're not done. We're not done by any measure because there's so much confusion out there, basically because we lack guidance. But it's a lot more deeper than that because so much of RIA has to do with events that have happened over the years. Today is another one of those areas that we need to talk about, which is all about things which happened 5-10 years ago and just got compounded, namely the way agents are treated. So today we have another practitioner who has a lot of years experience and she remembers the good old days. I won't call them the good old days, but the days with lots and lots of agents. That's right, Mona. On today's show, we have Jennifer Hermansky. Jennifer focuses her immigration practice on employment-based immigration and has experience servicing various industries such as healthcare, pharmaceutical, and real estate, as well as the entrepreneurs that make these industry innovations possible. She's helped structure over $3 billion in EB5 capital for various development projects while guiding thousands of families through the EB5 process. And she's here today on EB5 Investment Voice to help guide us for a better understanding on how to handle agents under RIA. Jen, welcome to the show.
Thank you, everyone. It's great to be here.
Jen, it's good to speak to you. You're one of the people who really understand just how much abuse we've taken over the years with agents.
Well, most projects have to work with a foreign finder or an agent to make their project successful. Agents are a necessary part, certainly, of the EB5 process. And right now, the focus by the USCIS and also Congress through the passage of RIA is to bring some more regulation in to the process with the foreign finders and the foreign migration agents into this EB5 process.
Right, I agree. But now let's just go back a little bit because I always like our listener to understand, especially the new ones, of the context that we're coming into. Over the years, some of the foreign finders in some countries, such as China, for example, have gone away with a huge, huge chunk of money, which nobody understood where it was coming from. It was never recorded. What have you seen of the industry? I'm talking a few years back.
Well, I think traditionally the foreign finders, they had agreements with the EB5 new commercial enterprises. I might also refer to them during this podcast as the issuer, so the people that are issuing the EB5 securities. The finders, they, I'm sure, had agreements with the issuers and the EB5 projects that outlined fees that would be paid. Many agents received fees out of the administrative fee that an investor pays. And also, they might have received, and probably did receive, some portion of return that went from the project to the new commercial enterprise. And then the new commercial enterprise distributes those returns for various things. They pay their own expenses. They pay money out to the foreign finders for finding the investors in the project. And they also, reserve funds to pay to investors, whatever preferred return is owed. So certainly in the past, foreign finders took funds from both the administrative fee and also some portion of the return that the issuer got in order to be compensated for finding investors.
Yeah. Mark, you may remember a couple of weeks ago, we had Sam from BLS on the call, and we did ask him. So Sam comes under an agent because he helps find investors overseas. And we asked him about this, and he was very quick to say, look, I have lots of expenses. The fees that I get paid cover my expenses. We don't deny that. We know that there are expenses, but I think Jen would be the first to jump up and say, yes, but some of these expenses and some of the fees don't correlate. There was a time, Jen, you may remember, there was a time where you had some investors, some agents rather, who were taking the full admin fee plus as much as 3 to 4% of the capital raised from the project. And the investor had no idea that this much was being paid out. I mean, not every investor, every agent, I hasten to add, but there were some.
I'm sure there were. And I think part of what is happening overall in the RIA law is just a focus on more disclosures to investors. I think this is really coming because the USCIS sees the news articles and other things that are out there. And they see, of course, the bad projects that are out there that have taken funds from investors. And a lot of times the investors say they didn't fully understand what they were investing in. They didn't fully understand the terms of the investment.
Yeah.
And I think that is true. I read these offerings and they are very complicated. They're complicated legal documents. They disclose many things about the projects and about the risks of the project and also the immigration risks.
So with all those risk disclosures, everyone understands what's happening?
Despite those things in those agreements, many people still don't truly understand what are they getting in return for this investment besides the green card, and what are the risks that they are taking on by making this investment.
Well, Jen, can you give us an example of some of those disclosures that investors can expect to get?
Some of those things are disclosures about the project, and obviously some of those things are disclosure about money and fees to third parties, which quite frankly has always been a focus of other agencies in the government, right? If we look to what FINRA or what the Securities and Exchange Commission might say about things like that, some of our securities colleagues, would say that disclosure is paramount in these documents, and understanding fees to third parties and your inducement into making the investment is an important part of the decision-making process. And so I think when Congress was passing the RIA, they thought, we want to have our own standards laid out and make sure that people are disclosing, because Mona, besides what you said about, some agents taking large amounts of money and things like that, there's also the other side of the equation, which is not every EB-5 project out there had good disclosure documents to give to investors, right? And so it becomes, an issue from multiple sides of, all right, how are we going to hold people to the standard that these other government agencies would hold these people to, and what actions and consequences can we make in order to make sure that those are, being followed by the various stakeholders in the EB-5 decision-making process.
But I think it's also important, Jen, to understand what is an agent, because people don't always get that. I mean, is an agent somebody who actually helps say somebody puts up an event in a foreign country and they help to market it, maybe put it in the local newspaper and stuff. Is that an agent if they are being paid money for putting that event up? What do you class as an agent?
Well, that is a great question. And I think many people in the industry right now are waiting for the USCIS to make a definition of that. So importantly, right now, even though we have had this law passed for almost 90 days since the
5
effective
months.
date.
Hello?
Yeah,
5 months.
I know. But since the effective date, we'll give them that. It's been about 90 days.
Jen, you're being so This is not doesn't sound like you.
Well, I do recognize that the agency has a lot of regulations to draft. Okay. And I think what I am telling clients and others in the industry is that there is a lot of room for the USCIS to make their own definitions of things and to make their own rules for things. And these sections on agents, what is an agent, what do the agents need to do, and what things need to be disclosed, there are various parts of that where the Immigration Service has serious work to do on definitions. So the RIA does not say who an agent is. And what's also confusing is that the word agent has a specific legal definition in the corporate sphere.
Yeah.
It's usually someone that can act on behalf of another company. Sometimes I think the RIA is using the word agent in that formal corporate term, and then they're using the term agent also to describe placement agents or foreign migration agents. I believe they use the word migration agents in one area of the statute specifically.
So you just use the word agent to define agent. That's a little confusing.
How lawyerly of me.
But going back to Mona's original question about people that put on events, maybe they're not representing an investor individual, but they have an event with multiple projects and multiple investors go. Would that fit your definition of an agent?
Yeah, this is yours.
Probably not. Probably not, in my own opinion.
I would disagree to a certain extent with you, Jen. If an event, say it's an event overseas or even a local event, produces an investor and the person who put on that event is paid a commission for that investor, that, as far as I'm concerned, comes under the definition of agents as far as EB5 is concerned.
Well, I think that your example just there is correct. A good way to look at it is how the other government agencies would also define the term foreign agent, right? They would define it as promoter, which in fact, the RIA uses the word promoter a number of times. They use promoter, finder, broker, dealer, or like agency, and they also use the term agent. So, when we look to other agencies like Securities and Exchange Commission or FINRA, which isn't, is a more quasi-government policing sort of thing, those agencies, I think, would look to whether someone is getting paid transaction-based compensation.
Okay, so here I'm going to, for our listeners, I'm really going to here put a distinction. We have to put a specific distinction between an overseas person who is providing an investor and taking transactional fees against a US-based person who has to be a broker-dealer.
Right. Each of these issuers of securities and foreign agents are going to have to look closely at the activities that they're doing and how they're getting paid and whether that is lawful under a host of laws, right? So not just under whether the RIA is, saying these activities are lawful and what needs to be disclosed, but also what these other government agencies would say about those things. But I think correct in terms of overall discussion about disclosure of fees and compensations, there are the group of individuals who are based abroad and then broker dealers inside the United States. And those disclosures seem to apply equally to them under the RIA.
Yeah. So right now, what do you think? Is it a good policy or do you think it's going to turn overseas agents away from bringing in investment into the US? Because I have heard on the grapevine that there are a number of agents who are not happy about registering.
I think there's two separate points there that you just made, Mona. One is, are they going to be happy about the disclosure of the fees? And the second is, are they going to be happy about the registration of the agent? Because those are two separate issues. So up until now, we've been talking about the fees and what the law says, what the RIA specifically says is that there must be a fee disclosure that is signed by the investor. Okay, so the exact words are, each petition shall include a disclosure signed by the investor that reflects all fees, ongoing interest, or other compensation paid to any other person. And so there, it clearly is a signal by Congress that they want these investors to know who are the third parties that are receiving fees as a result of this transaction, and who are the individuals that may receive some portion of the administrative fee or some portion of the return being earned by the new commercial enterprise where the investor is a member, and that the investor is sharing in a profit percentage with these other people that helped them, essentially choosing the investment.
Well, hey, Jen, let me jump in real quick before we get too much further. I want to do a little bit of role playing so I kind of understand what should be happening and perhaps what is happening with an EB5 investor. So they decide that they want to invest in a particular EB5 program without going into all the admin fees and then their return on their investment, which isn't guaranteed. We know it's all at risk. It sounds like the purpose of RIA is so the EB5 investors know who is getting paid both a fixed fee as well as who's being paid a variable compensation or commission from the return on that investment. Does that cover the admin fees and everything? What does it cover and what doesn't cover?
Yeah, you got it right, Mark. That really is what the whole purpose is. But Jen, we don't have anything yet from USCIS, as in we don't have a form, we don't have anything. So, and there's a lot of cases out there which are being filed right now. What do you suggest?
So right now, while we don't have any regulations and we don't really have any forms from the USCIS, the guidance that I have been giving to projects at this point is that the best place to put any disclosures about fees is in the subscription agreement, because the subscription agreement is the document where the investors sign to become a member of their investment company. That's where they sign on, and that's their legally binding agreement. So it makes sense if the law is requiring a signature by the investor that they understand all the fees being paid, that the fee disclosure is in the subscription booklet, and then that gets signed also by the investor.
Well, I think that's great advice, Jen, because here's the other issue. I'm hearing from some people, and I don't agree with this, that until there's a form, we don't need to disclose. Because I think the argument that would be USCIS would use was that this came in the law, and the law came into effect, March 15th or whenever. And therefore, even if we don't have a form out there, you have to just disclose whichever way you can. And what are the repercussions of you not complying with RIA? Well, the repercussions could easily be something related to a denial of the project or denial of the process, in which case the investor would be hurt.
I wholeheartedly agree with you. The section of the law makes clear that the petition filed, so the EB5 petition by the investor, has to include that disclosure and then be signed by the investor. And guess what? We did see USCIS publish the form I-526E to be used by the regional center investors. And guess what's not contained in that form? Anything about a fee to be paid by third parties. And I think it's because they don't want the investor writing that in there. I think they want the disclosure done by the issuer. It makes sense to do it in the issuer's document. and then have the investor sign where they normally would. There's lots of signatures in the subscription booklet where they're signing on to the agreements. So it makes sense to do the disclosure there.
And cynically, that new form will have another fee.
Probably. But for now, I would agree with you back to your original point, which is this law is effective. It's saying that the fee disclosures must happen in each petition filed. So what is the consequence? I think they could say that all immigration petitions must be approvable at the time that they are filed by the applicant. And if the applicant did not contain, give the appropriate fee disclosure with their own signature, they could say at the USCIS that your application was not approvable when it was filed and therefore tried to deny it. So I think it's possible that there could be consequences to the investor in their immigration petitions if they don't include this evidence. And I would not wait for a USCIS form in order to handle this.
Yeah, I totally agree. So back to a question I asked you a few minutes ago. Do you think this is a good policy, or do you think that practically it's going to turn some agents away from bringing in much needed capital investment into the US?
Well, I think there has to be a balance of everything. I do think it is very important for the investors to understand where their funds are going. And so perhaps instead of burying some fee deep into an offering document, it's right there for the investors to know and understand. So on that end, it's very good for the investors to understand who's getting paid what, and that makes them have a more informed decision about the investment that they're making. But beyond that, I do see the flip side of the agents, and I think that issuers are going to have to work closely with their securities counsel to determine what is the appropriate level of disclosure. Perhaps disclosure can be achieved by providing a range that is to be paid by, to various third parties. So I think that as long as those ranges are accurate, perhaps that will ease some of it, for the agents. But again, the disclosure is going to have to be accurate. And we still do not have any guidance from USCIS on what is an accurate disclosure.
I can hear the echo. But to be very fair with the agents, though, so there are agents who really do spend a lot of money in the marketing process, and it is not cheap. It's not like the olden days where you would go to China and you would pick up maybe a couple of agents who would market within certain areas and come up with 100, 200 investors. It is much tougher now. You have to go around the world, and there's inflation, and there's the cost of staff and the following up and all the rest. And I think also with the change of markets being, countries like India and stuff, where you're having people who really do ask a lot more questions and a lot more follow-up required, there is probably a lot more work as well.
And not just that, Mona, remember with the processing times at USCIS and also some of the backlogs that exist, many of the agents help these families through the process for a decade.
Yes.
So it's not as if they've just sent them a PPM and then gone away with it. I guess there are some agents out there that probably did that, but many of them are in fact helping to process immigration documents for these families through multiple steps of the process. They are involved all the way through the approval of the I-829 petition and maybe even thereafter. And they're providing support to these people on the ground, and they speak the home language. So they're providing services in some cases for a decade or more. So I think it's important to remember that also.
Yeah, I agree. But interestingly, in some parts of immigration law, say, for example, asylum, there's a specific certification that states that you have read the documents or they have been translated to you in your own language. There is nothing like that on EB-5. So there is an assumption that either you have had it accurately translated or you can read English.
That could be true, but I think the Immigration Service would say that anything that, you're turning over in your own EB-5 petition, you have read and understood. So I think the Immigration Service would take that position. You're submitting these things with your documents, and therefore you should know and understand them. And you're certifying that they're accurate. And so investors need to better understand the structures and maybe have some better guidance. And maybe this is one thing that the RIA will do to elevate the knowledge of investors by, having everyone understand, the agents included, what is the exact structure of the project and how are people receiving returns and what are the risks? Because I think a lot of the times the investors were maybe confused and overwhelmed by the complexity of the transactions, and the agents were just as confused. So perhaps these heightened disclosure requirements will lead everyone to a place where they understand more about the transactions.
Jen, is there any other area where there's a disclosure requirement, especially for fees, in EB5 project documents?
Yes. So each year when the regional centers are filing their annual statements, they have to account for all fees paid to promoters, finders, broker-dealers, or any other like agency.
Well, that's not new, though. That's been there.
Well, no, Mona, I disagree. There's no way that people were giving on their annual statements disclosures of fees that they paid to third parties. So the regional centers are going to have to keep a very clear record of it now, when payments are made and for what purpose and who received it. And then there's going to have to be a filing when USCIS finally gives guidance about what goes into those annual filings. The regional centers are going to have to disclose again to USCIS. It's possible that USCIS will say the regional centers' annual filings have to be disclosed to the investors. So they could come back to the investors that way also.
Well, yes. I mean, I totally agree. I mean, best practices is one thing, and practical practices are something else. Mm-hmm. But I have done a few representations in front of the SEC, and I can tell you the SEC do request all of this information. So each regional center should have kept it anyway. We were discussing earlier that you've even seen words to the effect of guidelines, or the fact that Congress is suggesting guidelines for permissible fee arrangements. What's all that about?
So in the RIA, there is a section where it says that Department of Homeland Security, or USCIS, they have to prescribe guidelines for direct and third-party promoters. And some of the areas are, number one, the rules and standards these agents shall abide by, which that's very vague. Number two, the guidelines for accurate visa process information. So I suppose Congress is telling USCIS that they need to publish some guidelines for agents about the way they describe the visa process to people. And then third, DHS should prescribe some guidelines of permissible fee arrangements. And so it looks like Congress is giving USCIS the direct instruction that they need to go out there and publish some regulations about what is a permissible fee arrangement. And right now, we obviously do not have any of those guidelines. So the best that people can do is to make as accurate disclosures as they possibly can in the offering documents.
Mark, are you here listening to all of this? This means that Jen has to come back once these forms are out there and discuss the forms with us.
That sounds like it.
And that's right.
Jen loves to talk about notice and comment period.
I do. And speaking of forms, there is a registration requirement by agents or third-party promoters that is in the RIA. And it says that foreign agents, migration agents, foreign finders should register with USCIS, including their contact information. And they need to confirm the existence of a written agreement between themselves as the agent and the new commercial enterprise, or the issuer of the securities. They also need to certify that they're a good actor under the RIA, that they don't have any convictions and things like that. Unfortunately, right now, there's no form available for agents to actually go ahead and do that registration. So that's another area where we're waiting for USCIS guidance.
Yep, we're waiting.
We're going to be waiting for some time, probably.
Well, it sounds like there's certainly changes afoot in the EB-5 industry, as always, Mona, right? And the EB-5 Reform and Integrity Act, or RIA, as we like to call it, it looks like it is putting the spotlight on a number of things, and that is including agents. And with that having been said, Jennifer Hermansky, thank you so much for coming on EB-5 Investment Voice and describing to us how agents should be handled under RIA.
You're most welcome.
Thank you for being with us today on EB5 Investment Voice. The topics presented in this podcast is informational in nature and is not to be taken as specific legal advice. If you have questions on the topics presented in this episode or other investment immigration needs, please contact Mona Shaw and Associates. Mona and her attorney staff can be reached at mshawlaw.com. That's mshawlaw.com. Make sure you don't miss our next episode focusing on a different aspect of the EB-5 program by subscribing to the podcast. While you're at it, leave us a rating on iTunes. If you really found this episode valuable, share it with someone else that could benefit from this information. Until then, I'll see you on the next episode of EB-5 Investment Voice.